The Russian Duma has decided that it will do a fuller process for its consideration of New START in what they call pursuing all three necessary readings of the treaty under their rules. Earlier today, as I understand it, is that they went to or concluded second reading, and the schedule that they have in mind is to go to third and final reading of what they call their ratification law on or about January 25th. The Duma is in the process of doing in a legislative form procedurally what the Senate did in certain ways with what we call the resolution of ratification in the Senate's ratification procedure or advice and consent procedure under the Constitution. That is that they're looking at adding to their record regarding the treaty any number of things that we over here in the United States would call conditions, declarations, understandings, or reservations to the treaty. Each of those terms have different meanings. Conditions, in our terminology, mean things that would be binding on the administration as it moves forward with the execution of the treaty. Effectively, these are agreements of what the administration must do in response to the Senate's demands in order to grant its consent to ratification. Those are essentially a purely internal matter to the United States. Declarations could be either internally focused or externally focused, and the Russians, even at the time of the signing of the treaty, as did the United States, issued such declarations. So that's an example of one going internationally. Or the Senate, in certain aspects of its resolution of ratification, had declarations about what it thought the administration ought to be doing. It's more or less like sense of the Senate resolutions. Understandings and reservations are a slightly different matter. An understanding says that one party to the treaty thinks that a particular provision included in the treaty has certain meaning. And they are included in what's called the instrument of ratification, each side of which has such an instrument, and they exchange to formally conclude the treaty. A reservation says, notwithstanding some provision of the treaty, is that one of the two parties will do X, Y, Z. So these are the kinds of things that the Russian Duma is looking at. Now, there's two that I think that really stand out in terms of the categories. And I must say at the outset that this is very much a moving target. I have not seen the language that the Russian Duma seems intent on including in its ratification law, so that what I'm talking about here is more or less speculative. But the two categories that I'm most focused on, because they're included in terms of the Senate's action in the resolution of ratification, fall in the area of what I've referred to as understandings. The U.S. instrument of ratification will include three understandings that have been mandated by the Senate to be included. And the administration has no choice about that. They must be included. They fall in the following areas: missile defense, rail mobile ICBMs and their launchers, and the question of non-nuclear strategic systems, or what we call prompt global strike. At one point, the Russian Duma was talking about trying to address all three of these issues that the Senate included in its resolution of ratification, then by extension into the U.S. instrument of ratification. But so far, in terms of recent weeks, I haven't seen anything really on rail mobile. So the two issues that are really key are missile defense, at this point in my judgment, and prompt global strike. It seems to me that the Russian Duma is effectively moving in the direction of attaching what we would call an understanding, meaning that there would be a statement in the Russian instrument of ratification that says basically two things. One is that the preamble to the treaty is legally binding, and two, that the Russians reserve, under unspecified provisions of the treaty, I'm not sure you describe it as a right, but I'm going to use that term, a right to charge the United States with a violation of the treaty if it takes any number of unspecified steps in terms of improving its missile defense capabilities. Well, the understanding that the Senate attached to the resolution of ratification and will be included in the U.S. instrument of ratification says essentially diametrically opposite things to what would be included in the Russian instrument. In the case of the prompt global strike, what the Russians are prepared to say is, as best I can understand it with this clearly not yet formal text, at least I haven't seen any translation of it, is that any form of prompt global strike system, including those that would be based on hypersonic glide vehicles, something that we consider non-ballistic and not within the traditional definitions of treaty-limited items under normal definitions, would only be permitted if the Russians permit them by agreement at the treaty's implementing body called the Bilateral Consultative Commission. The U.S. instrument of ratification will say, again at the instruction of the Senate, is such systems, aerodynamic lift systems, that could be used for non-nuclear strategic strike are not prohibited by New START in any way, shape, or form, including the numerical limits. Now, that wouldn't pertain to traditional strategic delivery systems. They would be subject to the numerical limits there. So once again, you're looking at a circumstance where the Russian instrument of ratification will say something that, for all intents and purposes, is diametrically opposed to something that's in the U.S. instrument of ratification. So then the question arises, if that is the circumstance, and that does turn out to be the case, when we actually look at the text of these, what's the remedy? To me, the proper remedy is for the United States to say, we're not going to exchange the instrument under those circumstances. And there has been precedence on the part of one that comes particularly to mind, a treaty with Turkey in the late 1800s, where the Turks, precisely because the Senate had insisted on certain inclusion of items in its resolution of ratification, chose not to exchange the instrument and not to bring the treaty into force. To me, that's the proper answer to the question. The more difficult question, and maybe Mike, you'd have some view on this, is it even legally permissible for the administration to exchange the instrument of ratification on those terms, or is it ignoring, by accepting the Russian instrument with this diametrically opposed provision or provisions, in effect vacating something that the Senate is insisting on? I don't know what the legal remedy is there, and it may not be one, but I certainly think that there is grounds for United States senators who are involved, obviously, in drafting these things that would be included in the instrument of ratification to challenge the administration on the question as to whether that's appropriate or not for them to accept the Russian instrument if it turns out to have the provisions in it that I think may be included, and see if whether there's a political agreement that can be reached between the two branches, the Senate and the administration, with regard to this, because something's got to give. I mean, at the end of the day, the circumstance that is really has arisen here is something essential to the treaty. It's shown that there's no agreement between the parties on. I mean, ultimately, in order to have a legally binding agreement, in my judgment, there has to be the political predicate that there's a real agreement on whatever the issue is. And it seems to me that these instruments of ratification are revealing a fundamental disagreement, and not just of any sort of disagreement, but one that is actually essential to the proper interpretation and implementation of the treaty. The one thing that the Duma has not done, which they could do, as the U.S. Senate could do, is, and indeed there was a proposal to do so in striking paragraph 9 of the preamble, which is exactly this issue about missile defense, is to amend the text of the treaty. If there's an amendment to the text of the treaty, which I assume the Duma could include in their ratification law, just as the United States could have included in its resolution of ratification following the adoption of an amendment to the text of the treaty, that would have to come back to the Senate for advice and consent. It would have to be drafted as a protocol to the treaty and considered as a treaty document itself.